County. Very happy to be with you here tonight to discuss extreme risk protective orders, or as we call them in the acronym, because law enforcement loves acronyms, Erpo. We're very lucky to have with us tonight Freehold Commissioner Director Rios is joining us tonight for this very important seminar. And I want to thank our partners in this matter: the Brady United Against Gun Violence, the National Association of Social Workers, the New Brunswick Domestic Violence Awareness Coalition, and Women Aware, who are our partners in this very important effort. Enacted in 2018, the Erpo Act is based upon the framework and procedure of the Domestic Violence Protection Orders, in which the state of New Jersey was a pioneer in bringing the voice to those who were victims of domestic violence. We have here in New Jersey one of the most comprehensive prevention of domestic violence acts in the United States, and Middlesex County has always been in the forefront of the actions to prevent domestic violence. I proudly, with my best friend from law school, Judge Marina Cordemus, we authored the first handbook for domestic violence victims in the state of New Jersey, and that was well over 35 years ago. Erpo is a civil court order issued by a judge upon consideration of evidence related to a number of factors prompted by family or household members or a law enforcement officer. The court must consider evidence of whether the respondent has a history of threats or acts of violence. The Irpo procedures are a mechanism for law enforcement to enact the temporary suspension of firearms for at-risk individuals. The goal of this act is to save lives in New Jersey, including the lives of the respondents and those around them. For the past 2.5 years, the members of our panel have become very experienced with the statute and have dispensed these kinds of issues throughout our county. At this time, I believe the next speaker will be Bureau Chief Jeff Burrill from the Office of the Attorney General, Division of Criminal Justice, Chief of Prosecutor, Supervision, and Training.
Thank you, Prosecutor. Good evening, everyone. How are you? All right, so first of all, that's a really tough act to follow, because normally when I get introduced at a training or a public community event where we discuss Erpo, we don't have a thorough introduction. So I could probably just cut my presentation in half, because Prosecutor Ciccone, also I know her as Judge Ciccone, really did a good job summarizing what Erpo is all about and the impact that it has on the citizens in our state as another tool that law enforcement and the community has to keep us safe. So my goal today is to go over a lot of the core fundamentals and the core concepts of Erpo, to discuss the process of how it starts out as a petition and how it ends up as a Furpo. And I'll go over all the abbreviations, symbols, and all that good stuff. All right, so terms. I think it's really important to deal with the terms that we are talking about in our training today. So the first one we have is Erpo. As Prosecutor Ciccone said, it's an extreme risk protective order. So it's the body of case law that's been enacted, that's contained in our 2C criminal code, that lays out the framework for the universe that we're working in. Within the overall concept of Erpo, we routinely refer to two subterms or phases of an Erpo. The first one is TERPO, very original. It's the temporary extreme risk protective order. And then we have Furpo, which is the final extreme risk protection order. So for those of you familiar with the DV world, there's the temporary restraining order and final restraining order. Comparable concept, and the way it's executed in court has a lot of similarities. All right, I see some law enforcement here and also some community members, so we throw around LEO a lot, and that's an abbreviation we use for law enforcement officer. LEA, I think you can figure it out, it's law enforcement agency. Mechanism that we have in our courts Petitioner is the word for someone who brings the petition. Some people may refer to them as plaintiff. It's the person seeking redress with the court or seeking some kind of action to be done by the court. They're the ones filling out the petition. Respondent is the person that the Erpo, or the Furpo, is being filed against. So it's the person that has to answer the accusation that's contained, answer to the court. So if you're familiar with state and defendant language, the respondent's really like the defendant. Same thing, plaintiff, defendant, that's the respondent. CPO is another abbreviation we use. It's County Prosecutor's Office. And DCJ is the Division of Criminal Justice. That is the criminal arm and the enforcement mechanism that the Attorney General has in the criminal justice system. Now, all of these terms are important as we go through the flow that's been established to handle Terpos and Furpos. All right, the statute. So although it was enacted before September 1st of 2019, I believe it was December of 2018, the effective date of the statute was September 1st. For those of you who have any political sway or influence, please tell your legislators that they should try not to have an effective date of a statute be on a holiday weekend, and that's what we had when Terpo came out. They should try to make it like on a Wednesday when everyone's around and can answer questions and work through kinks of new statutes. So that's a little community service advisement right there. All right, so when the statute became effective, it basically created a mechanism for a petitioner to apply for an Erpo, and then that's the universe of cases, right? It includes the temporary and the final, against a respondent who presents. Now, this is gonna be a phrase that it's a little clunky, but you're gonna hear it over and over again in the presentation today. So it's against a respondent who presents an immediate and present danger of bodily injury to themselves or to others by possessing or purchasing a firearm. Now, the statute lays out grounds to have an expedited hearing for the Terpo, for that temporary order that initially goes in and restrains the respondent from having access to weapons or purchasing weapons. And we'll talk about the ins and outs of that procedure. Now, once that Terpo is filed, the law clearly lays out that the respondent has a right to be heard about the final hearing, and that final hearing is going to be held within 10 days. Now, well, sometimes in all court matters, there's extensions, adjournments. Typically, in the practice area, we see respondents requesting additional time for a number of reasons. The most common ones that come up is if a respondent is in mental health custody. So they're committed to an institution. Obviously, they don't have time to put together a thorough response, and they'll request an adjournment. Courts routinely grant that. Additionally, if a respondent wants time to gather information to counter any of the accusations of the petitioner, they'll do that as well. All right, so both a Terpo and a Furpo ultimately have the effect of prohibiting the respondent from possessing or purchasing firearms or ammunition, and from holding any firearms ID card or other permits that it will allow them to possess, right? So what good is a restriction on someone from purchasing firearms if they still have their firearm purchaser ID card and they can go somewhere else and buy? So that's also contained in the language of the statute. Now, another thing that's contained in the statute, and we don't need to get too bogged down in the details about this because through both the court directive, which I'll throw up a link on here, and if anyone needs it, I can share it, and also through the Attorney General's directive on Erpos, we frame the constitutional standard for requesting a search warrant. So those of you that are either familiar because you're law enforcement with the probable cause standard, or if you're avid TV watchers and watch a lot of Law and Order shows, you know probable cause is the standard that you need to get a search warrant. If you read the statute, maybe it's not the most clear in there that you need probable cause, but when you look at the AG's directive and the court directive, it clearly establishes that you need that to get a search warrant. All right, the other interesting effect of the of having a Terpo or a Furpo issue against someone is that it now changes the class of respondent, or it changes the criminal exposure of the respondent. So in our body of case law, there's something called a certain persons offense. And also in our body of case law, there are contempt charges for those who don't follow restraining orders, and that's essentially what a Terpo or a Furpo is. So once a Terpo or Furpo issues against someone, that person is prohibited from possessing weapons. Obviously, that's on the face of the statute that we just discussed. But additionally, there's an enhanced criminal penalty for someone who does that. And that's a third-degree offense if someone has weapons and they're a certain person not to possess. So that's an enhancement contained in the statute. Also, if they violate by doing that, you can tack on a fourth-degree contempt charge. All right, so as promised, the Attorney General, when Erpo came out, issued a directive to help kind of establish a uniform enforcement of the law across the state so that we don't see disparities in certain counties based on how those counties handle firearm offenses. There's a link for that. And if anyone wants it, I can share the link. Otherwise, just search Attorney General Directives and you'll find it. Also, the AOC, that's the Administrative Office of Courts, they issued a directive on how to handle extreme risk protective orders. It gives instructions to judges on how to process and handle. It gives clear guidance to attorneys on how to enter appearances in those cases, and pretty much just establishes the rule of law within the court system of how to handle these. Both of these, like I said, are based off of the statute. They're compatible with the statute, and they take steps to ensure that the statute, as applied, passes constitutional muster. All right. One thing that we include in our Attorney General Directive on Erpos is making sure that we can spread the word about what an Erpo, Terpo, Furpo is, how to do it, who's eligible to apply for one, the protections under it, all of the factors that the court considers, because while the public is certainly able to research statutes and look up court rules, let's face it, oftentimes they don't. And if you're in a crisis situation and you speak to a law enforcement officer, we all know that law enforcement is there to help us. So we just memorialize in our directive that when a potential petitioner comes in with a concern where Erpo might be applicable, that law enforcement officer needs to explain what Erpo is about and talk about the protections. And again, we draw a lot of parallels between Erpos and domestic violence restraining orders. Same thing law enforcement does when they encounter a hostile scene where there's domestic violence. They advise the victim of their rights, the protections, and all the useful tools that they can have to both secure their individual safety and safety of their family. So in our directive, we tell law enforcement that they have the obligation to inform the public about it, and also to discuss who qualifies as a filer. And we're going to go and talk about that in a moment. Now, again, we have a lot of parallels between Erpos and DV matters. One thing that law enforcement will do when the public approaches them is they'll talk about both and talk about which one's more applicable to a situation. If they don't have the direct answer themselves, they'll call a duty prosecutor who's familiar with this, and they'll help craft the best law enforcement response to the situation. Sometimes that means an Erpo should file. Other times it means, well, maybe an Erpo should not file. Maybe a TRO should be entered. Sometimes even both. So, a quick chart, and we're going to talk about a little bit more of the specifics in a few slides. But a quick chart for everyone's benefit is when you think of the DV world, and I think a lot of people are familiar with the DV world, the petitioner must be a family or a household member, or someone who's like in a dating relationship with someone. There needs to be an act of domestic violence. So there has to be a predicate act of domestic violence, whether it's an assault, whether it's harassment, stalking, things of that nature. And the overall concept of DV restraining orders is to protect the individual victim's well-being. Similar but different are Erpos. So family or household members are included. Also, we'll go into some more subsects that mirror the DV statute. But interestingly, no predicate criminal act is required for an Erpo, right? And again, when I say Erpo, I mean Turpo or Furpo. You don't need a predicate criminal act. Don't get me wrong, a lot of times there is a predicate criminal act to, raise and heighten the petitioner's awareness of a situation to say, I think we need a Turpo here. But it's not required by the statute. And the overall concept and the public safety perspective of the Turpo is to help cure or prevent an immediate and present danger of bodily injury, and again, here's our phrase again, to self or others by possessing or purchasing a firearm. All right, so now, we spent a lot of time talking about the petitioner, who can file an Erbo petition. So, a family or household member can. A spouse or former spouse. A present or former household member. And that's an interesting thing. That's a little bit different. A former household member, so someone who's roommates with someone who has some kind of basis of concern and has a more intimate knowledge of someone than just the average person on the street. They can file one. A current or former dating partner, and someone who has or will have a child in common with someone else. So there's a lot of similarity between these and the DV statutes, right? Here's the brand new concept that Erpo introduces. Another class of eligible petitioner is a law enforcement officer. So we get lots of questions, and in the law enforcement officers and prosecutors that I speak to that handle the field of Erpos, they have gotten requests from neighbors, friends, family members, neighbors, friends, work associates, people like that. All of those folks, unless they meet one of the first column criteria, they're not eligible to file against. However, if they speak to a law enforcement officer and they outline all of the concerns that they have, and that gives the law enforcement officer probable cause to believe, hey, something's going on here, then our directive instructs the law enforcement officer to file that petition. And we'll talk more about that shortly. All right, again, so the respondent, fancy name for that's the person who the Turpo or Furpo is being filed or entered against. And it is the person that the petitioner is seeking the relief against. Here's an interesting concept. It can be a juvenile. A lot of people don't know that, but the law is completely silent on it, and in practice, it can be a juvenile. Can also be a law enforcement officer, and there are special rules that apply both in the statute as well as in the AG directive and the court directive of what to do if it is a law enforcement officer. All right, so now let's talk about the petition. Where can this be filed? It can be filed at a superior court or any state, county, or municipal law enforcement agency. So you want to talk about open doors and access to this petition? You can pretty much file it anywhere where law enforcement operates. In practice, we see a lot of people going to the court. They head down to criminal case management and ask for it to be filed, or we see them calling their local law enforcement officers and entering a standard request for service. They call 911, they call law enforcement because they're concerned about a loved one, or unfortunately, we've seen a lot of people call about spouses or children who are going through really bad episodes of depression or a mental health issue. But open access, there's lots of places where it can be filed. Slightly different rule if it's a law enforcement officer, and we'll talk about that. Now, the petition for an Erpo, a Turpo, Erpo, Furpo, is on the court's electronic system. And again, separate for law enforcement officers, this does not apply. But for everyone else, it's on the ECDR system. So that means that the agencies you're going to, whether it's a municipal court, a superior court, or your local law enforcement agency, they all have the ability to file the petition and assist members of the public in filing these petitions on the ECDR system. It's a very user-friendly system that law enforcement can use in conjunction with the courts. It makes it so that we're not trying to read chicken scratch handwriting, and that information is clearly communicated and quickly replicated and transferred to people. So it's I'm sure the AOC will appreciate this plug here, but it's a fantastic way to enter information into the court system that really improves the efficiency of justice. All right, now, we're talking about location. The law and the directives require that the petition be filed either by the court or law enforcement agency in the same county where the respondent resides. We're going to talk about why that's important in a moment. If the petitioner comes to a law enforcement agency in a different county, that agency is instructed to find out where that petitioner lives, coordinate with law enforcement in that jurisdiction so that that petition can be filed in the proper jurisdiction. So the reason that's important, it really just flows logically. When you're looking at a respondent and the information that we're going to talk about a little bit later about all the factors that a judge considers for these petitions, it makes sense to have it be investigated and filed in that person's home area. The reason is law enforcement has access to call logs, call for service. They may have experience with a particular respondent or a history, or have more ready access to that history. The court system may have information that's readily available that another county may not. And the prosecutors there also are aware of, obviously, their home turf and what court actions are happening there. They also have the ability to search all the other things that I mentioned that law enforcement would have, calls for service, 911 requests, any other parallel issues that could impact on the petition process for a TURPO. So the example that I usually give in this situation is, let's say someone's in that dating relationship or former dating relationship, and the petitioner moves away, but they're still in communication and close contact with their ex. And the ex is feeling depressed, going through a suicidal episode, and they're speaking to that person on the phone. Well, when that happens, and that petitioner is concerned, and they call law enforcement in their jurisdiction, that law enforcement officer is going to reach out to the responding agency so that there can be a safety and wellness check done, and they can also look into what other calls for service have been there. And again, home turf, they know what may happen at that address or with that person and have some kind of background on the respondent. Okay. When a petitioner comes into an agency, they need to advise the petitioner of the procedure for completing and signing the petition. And remember, we discussed it's on the electronic system. That law enforcement agency has to assist the petitioner in filling out the form. So they'll sit there. In practice, it's a very collaborative process. They'll sit there and talk to the petitioner that's coming in and go through each field and help them enter all that information. All right. Also, a law enforcement agency may assist the family or household member in preparing the overall petition, including giving information about all of the factors. So if someone comes in and they have all the information, law enforcement must assist them in entering that and filing it. And if the situation allows and it's appropriate, they can also have a more candid conversation with them and pull out some additional information if they're not presenting facts that would lead a court to grant a TURPO. All right, the contents of the petition. So we know we have a really strong law enforcement tool here, and we know that time is kind of sensitive, and the court needs as much information in front of them as possible to make a decision on this matter. So the contents of the petition are very important. Primarily, they have to make the allegation that the respondent, and again, here's our standard, poses an immediate and present danger of bodily injury to themselves or others by possessing, purchasing, owning, or receiving a firearm. The petition must not just just blankly state that. It has to have some support behind it. So it needs to set forth the specific facts and the basis of knowledge that the petitioner has to have these concerns about the respondent. They also have to talk about their knowledge of what the danger is that the respondent poses either, again, to themselves or others. The petition also has a section to include information about the number, types, descriptions, and locations of firearms, ammunition, also identity, like the firearm identification card, the purchaser permit, pistol permits, anything like that. And all of that, for those of you in the law enforcement field or who watch those TV shows closely, know that this is the information that helps us develop probable cause that firearms could be found in a certain location or a certain, that firearms themselves are going to be found. The petition may also reference documents. What we see a lot in practice on these is that people will reference Facebook posts, social media posts, where someone is sharing some violent thoughts, something they want to do with firearms and why, and it's really the best proof that someone could pose a danger to themselves or others is right there in a video clip on TikTok or Instagram. So the petition can reference documents like that, and law enforcement officers and prosecutors are skilled at helping petitioners get that and preserve that information so that it can be reviewed by the court at a later time. And also, the petition must be sworn and given under oath. This is an important feature by design because this petition, I think you can all determine, has a lot of power against the respondent. So anyone who's coming in and making a bunch of lies should have some kind of mechanism or some kind of recourse if they come in and lie about it, they're making things up, or they're trying to jam someone up, hurt their job, anything like that. So it's under oath, it's submitted as an official court document, and if there's perjury inside or anything's willfully false, there's going to be punishment. All right, so the category of law enforcement officers as the petitioner. So again, that's the unique category that's different than DV action. So law enforcement, they are allowed to file their own petition. We see that in examples where law enforcement's out just doing their regular job and they encounter someone who meets the Erpo standard. When they do that, when there's probable cause to believe that, our directive requires them to file an Erpo petition against them. So again, filing is where the law enforcement officer is the original petitioner. They are allowed to take over a petition. So a law enforcement officer can take over a petition that was originally requested by another eligible class of person in that statute, and they ultimately become the sole petitioner in that case. I don't think we've seen too many of these. However, it's designed so that if someone comes in and they outline a very credible case that gives a law enforcement officer probable cause to submit one of these, but now that original petitioner, the family member, the ex, it's like, you know what? I don't want to be involved in this. I'm concerned for my safety. I'm going to be unavailable. I'm going in for surgery. I'm not going to be able to show up in court in 10 days and present any testimony you need me to present. Law enforcement, please take this over for me. So that's a situation where law enforcement can do that. And it can be after the petition filed. They may come in, give you everything. They would be the petitioner. And then a day later, they're like, you know what? I want to back out of this, but the facts haven't changed. Law enforcement still found the information that this person, the respondent, poses a risk to themselves or others by possessing firearms. They can take over that petition and substitute themselves as the petitioner. And they can also join. They can be a co-petitioner with someone. And again, I don't think we've seen too many of these because either they take it over wholly or the original petitioner is just moving forward with it. So in our directive, the Attorney General requires that a law enforcement officer shall either file, like we discussed, or take over a petition if there's probable cause, Right, so the initial standard, if you go back, we discussed good cause for the petition to enter. There's a number of different legal standards that we have, all the way from reasonable suspicion to beyond a reasonable doubt. It's a scale of burdens of proof, with reasonable suspicion being the lowest and beyond a reasonable doubt being the standard you need to convict someone at a criminal trial. So whenever law enforcement bumps that standard up or sees that the facts present themselves that there's probable cause, they need to take that over. All right, now, the Erpo hearing. I mentioned in the beginning, it needs to be heard in an expedited manner. Expedited is expedited. There's no set definition in the statute. It just means as quickly as possible. I've heard of situations where the law enforcement officer doing the intake calls the duty judge, and the duty judge says, yeah, I'm ready, let's go, I'm hitting record. So it's that quick. And I've heard of situations where the law enforcement officer says, hey, I have all this information, I'm getting a couple more things, can I get a judge in 20 minutes? And the court says, absolutely, call me back at this number. So expedited really does mean expedited. It'll be as quickly as possible. It needs to be recorded, just like a petition in a domestic violence case. If someone's going for a TRO, it's going to be recorded so that it can be reviewed. Now, venue. It's going to be set, like I mentioned before, in the county where the respondent lives, unless the respondent lives out of state. That's one little switch to it. If the respondent lives out of state, then it's where the petitioner lives. So there needs to be a nexus to New Jersey. I think the situation where we've seen this come up, because it's a bit unique, is where a respondent lives out of state but owns a vacation house here. And then there's a concern that the person's just gonna come right over and have access to their weapons in New Jersey. So it may be a bit odd when you're reading it to say, well, why would New Jersey have jurisdiction over a respondent that lives out of state? But that's one example. Another one can be if a petitioner lives in New Jersey and the respondent lives out of state but has friends in New Jersey, goes to school in New Jersey, and they say they're gonna come to New Jersey and they have all the facts that make them meet that Erpo standard, then it can be issued. All right, so now if, there's no time limit on when this can be done. However, where it's initially heard depends on the time. So during the day, normal court hours, 8:30 to 4:30, it's going to take place, the hearing will take place in the Superior Court. After hours or a holiday or weekend, it's going to be in a municipal court with a municipal judge. The court has the ability to hear all of the evidence presented in the petition, and they also have the ability to examine the petitioner. So the petitioner can be made available on the phone. Usually it's a law enforcement officer speaking to the judge, or the judge can solely rely on the affidavit. Obviously, you know, we prefer when judges examine the petitioner so they can ask all the details that they need and ensure that that the story, I don't want to say checks out, but is consistent, internally consistent. There's a lot that you can get from talking to someone to gauge credibility, but the law does allow for both. And generally, the respondent does not have an appearance here. Similar to the temporary restraining order in the DV world, the respondent does not typically have a voice at these. In fact, I can't think of a situation where I was made aware of a Erpo where a respondent was a party to the conversation with the judge. All right, now in a Erpo, once all this information is filtered to the judge needs to consider the Erpo factors. We're gonna cover those in a minute. But the legal standard for the court to apply in issuing the Erpo is whether there is good cause. There's no legal definition for good cause, which is really tricky. But everyone agrees that it's more than a reasonable suspicion and it's just shy of probable cause. But good cause to believe that the respondent poses an immediate and present danger of causing bodily injury to either the respondent or others by having custody or control of, owning, possessing, purchasing, or receiving a firearm. Now, Remember, I gave that little flag before that the standard for a search warrant's probable cause. Hyper-technical, just for one moment. The statute says it, for good cause, the court can issue the Terpo and also issue a search warrant. So what we did with the AG directive is cure that by saying, if you're going to get a search warrant, you need to meet the probable cause standard. All right, here are the Erpo factors. There's 11 core factors that a judge is going to consider in reviewing these petitions. And then after those 11, if any of those 11 are found, then there's another set of factors, and I'll go over those as well. The first factor, is there a history of threats or acts of violence that's directed toward the respondent's own person, to themselves, or to others? A lot of these are pretty intuitive about why this would be an important factor to consider before you issue a Terpo, if you were a judge, but I think it's pretty clear why this factor is important. Similarly, the court can consider if there's a history of use, attempted use, or threatened use of physical force against another person. Also important for the court to consider is whether the respondent has either been the subject of or they have violated either a TRO or an FRO. And that's all issued under the Prevention of Domestic Violence Act. The next factor is whether that subject is either that respondent is the subject of or has violated a protective order that was issued under SASPA, and that's the Sexual Assault Survivor Protection Act. Whether the respondent has any prior arrests, pending criminal charges, convictions for a violent indictable crime, or a disorderly persons offense, stalking offense, or domestic violence offense. Now, one thing here, let me just go back 1 minute and I'll cover it again. For these 5 factors and for the balance of the factors, remember there's 11 initial factors. There's no magic formula that the court applies in weighing these. And I think the statute is left that way to really allow the judge to use their discretion and consider all of the facts in total to see whether a Terpo needs to issue against this person, or similarly, these are the same standards of whether a Furpo should issue against the person. So there can be just 2 factors that are so egregious and compelling to the judge that really outline that the respondent is going to be a danger to themselves or others, that the respondent is that close to pulling the trigger and killing themselves, or they're going to go and commit a mass shooting. And those 2 factors can carry the day, and a Terpo can issue. Similarly, there can be a whole bunch of factors that are checked off, but there's not a lot of weight to them. So if you see someone who has, a really lengthy criminal history, but when you peel back the layer, it's all for shoplifting, and there's no indication of violence there. And there may be a prior threat or act of violence, but that prior threat or act of violence was bar fights, and they threatened to punch someone in the face, and it's always the same repetitive factor, and there's never any indication about firearms or any kind of mass firearm violence. You can have a lot of these factors ticked off, but it may not get you the Terpo. All right, the next factor, whether they have prior arrests, pending charges, or convictions of any offense involving cruelty to animals, or any history of acts involving cruelty to animals. That's what the legislature put in there. I'm sure there's a scientific nexus towards someone's history of cruelty to animals and their propensity to commit a violent act with a firearm. But that's one of the factors that I wanted everyone to be aware of because it's in the law. Any history of drug or alcohol abuse and recovery from this abuse. Whether the respondent recently acquired a firearm, ammunition, or other deadly weapon. And we've seen that in petitions that come in. Someone all of a sudden becomes concerned about a loved one because the loved one, although has had no indication or any previous history of mental illness, starts exhibiting signs of mental illness, They start on long-winded rants about things, and then all of a sudden they say they want to fix problems by going to get a firearm. They head out, they fill out all the paperwork, do the background check, and that concerned family member or other eligible petitioner is like, this is very unlike them, I'm concerned. And then they talk to law enforcement to share that concern. The next factor, whether that respondent has recklessly used, displayed, or brandished a firearm. We've seen a lot of these as well. I know I mentioned before, social media can be referenced in the petition, and lots of folks will do things with weapons and firearms on social media where it is clear as day that they are recklessly using that weapon, displaying it, or brandishing it in a situation. The next factor, whether that respondent has an existing or previous Erpo issued against them. I think that one makes sense. That's not to say I don't think the other ones make sense, but 10 and 11 are pretty clear. And also whether the respondent has previously violated a Terpo or a Furpo. So as I said before, very important, these are the 11 core factors that the court has to consider. There's no magic formula about the weight. They can find a ton of weight on one, and that can make it so the Erpo petition doesn't enter or doesn't turn into a Terpo, or they can find a medium amount on multiple factors, and that can get it done. Once a court finds any of these factors, they are then allowed by the statute to consider a few other factors. Whether that respondent has any prior involuntary commitment in a hospital or treatment facilities for persons with psychiatric disorders or disabilities. Whether that respondent has received any mental health treatment. Whether that respondent has failed to comply with the mental health treatment, and whether that respondent has received a diagnosis of a mental health disorder. We've seen petitions come in where there's one of the other factors, and the court then moves to the additional factors they're allowed to consider, and there's information in there that a family member knows, a roommate knows, a spouse knows, that the person was on some kind of psychiatric medication, they were doing totally fine, then they stopped, and now things are not so fine, and they have a concern for that person's safety or the safety of the public. And then that's why these factors are there. I think it's important that you need one of the other factors first before you consider these, because we don't want to have a negative stigma on mental health treatment or someone going and being responsible to speak to a psychiatrist or to commit themselves if they feel like they're in a bad way and they're going to place others in harm or place themselves in the path of harm. So you do need one of the other factors first before you can consider these. Okay, now, the court, in addition to getting the information on the petition, can get additional information. I was talking about calls for service. I was talking about whether there's other criminal acts that are pending against the person. So whenever there's information gathering, it's the responsibility of both the law enforcement agency or the county prosecutor's office to aid in the overall review of that petition and provide this information both to the court and, for those of you who are familiar with just the criminal discovery process, provide that information to the respondent. So the respondent has an opportunity to review all the information and materials that are being offered against the respondent's interest, and they can answer for it in court. This also includes anything that touches upon all the 11 and then the supplemental Erpo factors that the court considers. All right, so once we have the Turpo hearing and a judge decides there's good cause to issue this Turpo, then we get to service of the Turpo. So once the Turpo is issued by the court, that needs to be sent to, the court will send it to the county prosecutor's office and the law enforcement agency where the respondent resides. There's an electronic warrant system, restraining order system that forwards and pushes this information to our county prosecutors' offices and law enforcement agencies. Law enforcement officers are already well-versed in receiving those and serving them in the DV world, and they do the same in the Turpo world. So once that comes in, they ready themselves, they follow their internal procedures, and they go and serve the Turpo on the respondent. Once that Turpo issues and a judge signs it, the Turpo and also the Furpo remain in effect until there's a further order. This is interesting because other jurisdictions in other states that have Erpo laws have an automatic expiration date on either the Turpo or the Furpo. New Jersey does not have that. So if a Turpo issues, and in the situation where I mentioned that the Furpo hearing has to happen in 10 days, but the respondent is in a mental institution or receiving some kind of psychiatric treatment, no court action has to happen. The law enforcement officers don't need to file a supplemental petition. The courts don't need to do any special process. It's automatically still in effect. So all the protections that the law grant against the respondent remain in place. And then there's important information that's contained in the Turpo order. Specifically, it gives the respondent the notice of when to appear in court to answer and attend and participate in the Furpo hearing. All right, we spent a little bit of time talking about the search warrant. If the facts rise to the probable cause level and there's enough to issue a search warrant, then the law enforcement agency where the respondent resides is going to execute that search warrant as quickly as possible. And again, there's no set time period that's established because the law takes into effect or it takes into consideration that law enforcement officers need to plan a safe and effective execution of a search warrant. They need to make sure they have the appropriate backup there so that all parties involved remain as safe as possible. When they do that, law enforcement officers with that search warrant must seize all firearms and ammunition within the respondent's possession, custody, or control. This includes weapons that may belong to someone else that the respondent has access to. This causes a lot of post-Turpo search warrant execution, activity, because a lot of times we'll see roommates, spouses, friends, family members come in and say, whoa, you took my weapons in addition to his weapons. I want those back, I need them, it's hunting season, or I'm about to sell those at auction, or I need them for my personal security. And those situations are dealt with on a case-by-case basis within a prosecutor's office and a law enforcement agency to ensure that, one, they actually belong to that person, but two, if they are returned prior to any final hearing, that there's some kind of mechanism in place where the respondent doesn't have access to that. All right, so we covered the Turpo. Now we're gonna go into the Furpo. I've mentioned probably 3 times now that it has to happen with 10 days unless it's extended, and it's gonna be in the same county where the Turpo happened. Now, in the Furpo hearing, the respondent has the right to be present, to present to the court documents and witness testimony. And we've seen a lot of these hearings happen, where the respondent comes in and says, the petitioner has it out for me, there's no way I'm a danger to myself or others, I'm a responsible firearm owner, here are my witnesses, here's my history of owning firearms, and then the judge has to weigh those things while they're reviewing the overall final determination for that Furpo. And the factors that we discussed are the factors that the court considers. All right, the standard that we had at the very beginning for Turpo was good cause or probable cause, right? For the Furpo hearing, the legal standard shifts, it elevates a little bit before that final order issues. And the standard is whether by a preponderance of the evidence. Now, preponderance of the evidence and I won't bore you with all the details, but it is a higher level or a higher burden of proof than probable cause. It is a standard in New Jersey that's used in custody determinations. So we're still not at that criminal level beyond a reasonable doubt, but we're right below it. I'm sorry, I misspoke slightly. It's our civil burden standard. So preponderance of the evidence is our civil standard. Clear and convincing is elevated above that. Clear and convincing is the one for child custody determinations. I apologize. So this is the civil standard. So it's more likely than not that the respondent poses a significant danger of bodily injury. Again, here's our same factor that we've been repeating the whole time. To the respondent self or others by having custody or control of, owning, possessing, purchasing, or receiving a firearm. Now, just because we get a search warrant, just because we don't get a search warrant in a Turpo situation does not mean the court loses its ability to issue a search warrant in the Furpo hearing. The court, when all the evidence comes together, can make a determination, and law enforcement can request one, that based on that 10-day period where the law enforcement officers can be doing additional information gathering, additional investigations, working with prosecutors to find out additional details, that can ultimately lead to a search warrant issuing if there's information like, hey, this person actually still has access to firearms, and here's where they are. A search warrant can issue. But again, we need that probable cause. All right, so again, at the Furpo stage, just like we had in the Turpo stage, the law enforcement officer or the county prosecutor's office where the respondent resides must produce any evidence that they have that's related to the Erpo factors that they're going to be relying upon at that Furpo hearing. It's the basic concepts of discovery. All right, we'll talk about appeals quickly. So there's situations where a Turpo is denied. So the petitioner's request is denied by the judge. When a municipal judge is the judge that's hearing that Turpo petition, to appeal them, the petitioner can request an immediate review of that hearing, and that's on call to a superior court judge. So that can happen instantly. When that happens, the law enforcement officer is responsible for calling the superior court judge to facilitate that appeal. If a superior court judge, right, so if you remember back to one of those first slides, if you're making this during regular court hours, it's not a holiday, not a weekend, the superior court judge is going to hear your petition for a Turpo. So if a superior court judge made the determination, that petitioner can file an appeal to the appellate division, and that tracks the normal appellate track. So they have 45 days to file that appeal. When it comes to Furpos, for either appealing the fact that one was granted or that one was denied, that's done by a superior court judge. It's not done by a municipal court judge. And the petitioner or the respondent can appeal the decision to the appellate division, same appellate track. They have 45 days to submit that appeal. All right, we're going to spend a little bit of time talking about what happens when a law enforcement officer in New Jersey is the respondent. So when a petitioner seeks to file a Turpo against a law enforcement officer, first of all, it must be a New Jersey law enforcement officer. This doesn't apply to out-of-state officers, so a Pennsylvania police officer. It doesn't apply to an FBI agent that lives in New Jersey. The statute doesn't cover them in this way. They would just track like a normal respondent under the statute. So when there's someone who wants to file a Turpo against a New Jersey law enforcement officer, there's a different procedure that has to take place. That petition may only be submitted, and I'm going to say submitted because it's not officially filed with the court yet. It must be submitted to the law enforcement agency where that respondent police officer works. That's what the statute calls for. I didn't write the statute, but I've heard people discuss this provision, and ultimately what a lot of people discuss with why this was enacted was that law enforcement officers already are subject to so much scrutiny by their internal affairs group that there's a lot of information that is not public that internal affairs officers may know about law enforcement officers. Additionally, law enforcement officers in their agencies, there's typically other evaluations of law enforcement officers that happen. There's fitness for duty evaluations that can be filed against an officer when certain standards are met. And IA officers are already used to doing these investigations on a very tight turnaround. And it's important for the IA process to know that someone is making these allegations against police officers. If these were filed in the court, there could be a delay in getting that information to an agency so that there's a delay in conducting that investigation. So these are some of the reasons that I've heard about why the law is carved out separately for law enforcement officers. And again, it's mandated by the statute. So when that happens, it's on a paper application. It is not submitted on the ECDR system and not funneled to the court. So the law requires, and the AG directive follows it and sets forth the standard that it should be done, that this law enforcement agency must immediately initiate an expedited IA investigation. And that investigation is done on a very, very tight time frame. They have 48 hours to conduct that investigation. So if the law enforcement officer that's responding to or handling that Erpo IA, if they have probable cause based on the facts that are presented to them, the same rules apply with regard to how they would handle other issues that are that a law enforcement agency is made aware of about one of their officers. They must do an immediate fitness for duty evaluation where they have to review whether the presence of weapons would expose that respondent officer or others in the community, anyone, to a risk of bodily injury. Then that law enforcement agency and their employer must immediately seize all of the weapons, whether they're department issued or whether they're personal weapons of the officer that are possessed by the respondent. This is a very similar process to what happens when a TRO issues against a law enforcement officer. It's an expedited seizure that's done by the law enforcement agency. Oh, that was out of order, I apologize. So going further down that line for law enforcement officers, once that 48-hour expedited investigation is complete, or it can be before the 48 hours if everything is done before that time frame, they have to send the investigation results and the conclusion of that investigation to either the county prosecutor's office or to the Division of Criminal Justice. And it depends. The difference between a county prosecutor's office or DCJ is based on the affiliation of the state law enforcement officer. So if it's a municipal law enforcement officer, that goes to the county prosecutor's office. If it's a state law enforcement officer, so a detective at the division, someone with state police, that gets funneled to the Division of Criminal Justice for review. They then have 1 business day to make a determination within the bounds of the statute and the AG directive about whether there's sufficient evidence for this to go forward. And the standard is if there's probable cause. And again, it's to believe that there's an immediate or present danger of bodily injury to that respondent or to others by the possession of firearms. If that office, so the prosecutor's office or the division, makes that determination and it goes to the highest level of that office, if they make that determination, then the petition files in the regular course. So it goes into the ECDR system, and there's the expedited hearing for the Turpo, and then that information is shared with the judge. If it doesn't meet the standard, then the original petitioner who came in gets notice that it's not being filed. And also the officer, the respondent officer, gets notice of that as well. Okay. Now, what happens when firearms are seized during the Erpo Turpo process? So the law enforcement agency or the county prosecutor's office, now I'm looking at the cops in the office, and I'm sure you guys want your prosecutor's office to have these, and I'm looking at the prosecutors here, and I'm sure you want that evidence to be stored at your local law enforcement agency. It really depends on what jurisdiction you're in of who has them, but regardless, law enforcement is responsible for taking these in, whether it's the prosecutor or the municipal police, state police. Now, like we talked about before, someone other than the respondent can come in and claim title to the firearms and ammunition, and then they can weigh what can be done. There's court process to fight someone who, and I don't want to say fight someone, but to have the office hold on to the weapons when there's a nexus to the Turpo petition, and if the owner has an issue with that, there's court process that's available to them to be heard, so that it's not just law enforcement saying this is our way or the highway. There's court process to handle all that. But I have not heard of any cases where there's been a lot of pushback when the standards met, because genuinely all parties involved are concerned about the safety of the respondent and making sure they don't have access to those weapons. In a lot of situations, we see a respondent who acknowledges that they're in a bad way and they don't want to have access to these weapons. If you would have asked me before this law went into effect whether we'd see a lot of those cases, I would have bet against that. But there are a lot of people who say, you know what, I should not have firearms. In those situations, we see that respondent asking the law enforcement agency or the prosecutor who's in charge of the weapons dispositions to have a firearms dealer come in and purchase those weapons and transfer them out of that person's name and take them away. This way they can get the money from that, or just make sure that they don't get destroyed or held up in limbo for forever. They just want to resolve the matter. All right. Now, the last part of the whole Erpo petition world is what happens if we get to a point that someone says, okay, well, there was a Turpo, there was a Furpo issued, and it's time to have it terminated. I'm better now. I don't want to have this prohibition against me for having weapons. The state says, you know what, we're looking at it. There is an outlined plan of mental health treatment. This person did that over the past year. They've been multiple years without any sort of indicator. You know, it's probably, you know, the petition or the respondent has come forward and said that they want to not have a Furpo anymore and they want to have it disposed of. There's a process for that. So a petition for the termination of a Furpo can be filed at any time. And it can be filed by either the petitioner, who originally got the Turpo or Furpo issued against the respondent, or it can be filed by the respondent. One thing that I wanted to point out is that this petition for termination can be filed at any time. Other states have prohibitions on when it can be filed, or they have a set schedule of how frequently it can be filed. It's not the case in New Jersey. And just like any court process, there needs to be notice. So to the other party. So if a petitioner comes in and says, I want to file to remove this, I'm not concerned anymore, then the respondent needs notice, the prosecutor's office gets notice, and the law enforcement agency gets notice. Similarly, the respondent comes in, the petitioner gets notice, and also the CPO and the agency. And there needs to be a court hearing. Now, at that court hearing, it's usually the prosecutor, but the prosecutor or the law enforcement agency can file an objection. And just like the court did in issuing the Furpo or the Turpo, they go back to the factors and weigh all the factors. They weigh a history of mental health treatment. In the hypothetical I just posed to you, they weigh all these other factors that would lead towards either granting or denying whether that petition for termination should be granted. The burden that the respondent has is the same burden that the court or that the petitioner had to meet when the court was issuing the Furpo, and that's preponderance of the evidence. So the respondent must show the court in requesting this termination that they no longer pose a significant danger of causing the bodily injury to themselves or others by having access to firearms. If they meet that standard, the court will terminate the Furpo, and the respondent can then petition the prosecutor's office for return of their weapons and ammunition that was seized. And the prosecutor's office has 30 days to return those weapons if there's no other legal bar to that person having weapons. So the real world example of what I mean by that is, let's say a respondent had both a Furpo issue against them and an FRO issued against them, but all of the Furpo factors are gone. They successfully petition for the removal of the Furpo, but that person still has a restraining order under the Domestic Violence Act issued against them. Prosecutor's office can't give them their weapons back. So that's the bar to them getting their weapons back. So I know we covered a lot in that period of time. I know that this is maybe not the most interesting topic in the world, but I hope you all took something away about this tool that was added to law enforcement's toolbox, to the public's toolbox when it comes to dealing with folks that may be a danger to themselves or others with firearms. I can take any questions you may have. Also, I know that the prosecutor's office and local law enforcement agencies, for those of you that are members of the public, they're always around to help you. If you have any concerns about an issue where someone could pose a significant danger to themselves or others, reach out to your law enforcement agency. I always say, if you see something, say something. Law enforcement is there to keep everyone safe. I speak to law enforcement officers day in and day out, and it may sound a bit cliche, but that's why they signed up for the job. That's what they want to do. And I can't think of a single law enforcement officer that would be annoyed if someone came up to them and said, I'm concerned about the safety of the public because this guy has access to guns. They'll talk to you about Erpo and Terpos. They'll walk you through it, and they'll help you figure out what you need to do. So thank you all for your time. If you have any questions, please shoot a hand up. All right. Oh.
Thank you so much.
Oh, there's someone in the back. Yes, sir.
Charlie, can we just hold off for 1 second? We have a little more information, and then all the questions.
There we go.
All right. Thank you to Deputy Attorney General Jeff Burrill. We can't thank him enough for being here and for providing this information. I would like to call upon at this time Section Chief Judson Hamlin. He is in charge of our pretrial unit at the Middlesex County Prosecutor's Office. And very briefly, he's going to give us an overview as to the Middlesex County perspective of the Erpo provisions in state law since its enactment in 2019. Judd Hamlin.
Thanks, Chris. Okay, good evening, everybody. Thank you. Thanks for coming tonight. Thank you again to Jeff. I want to talk to you very briefly a little bit about where we are in Middlesex County specifically with regards to how Erpos, Terpos work once they hit our office. The pretrial unit does handle all Terpo matters. Right now they're being prosecuted by Assistant Prosecutor Lauren Panfile, who's here tonight, but they are within our pretrial unit because we have attorneys assigned as legal advisors to every law enforcement department in Middlesex County, and it is to them that we turn to build relationships with local law enforcement, and they are in the best position to get and share knowledge with law enforcement officers, and then to help make decisions about Terpo applications, and to gather information that we need when we're going to prosecute a Furpo hearing. And since the enactment of the law in late 2019, Middlesex County we have completed 45 Terpo hearings, Terpo applications that have gone for final action in front of a Superior Court judge. Of those 45, there are, I think, 6 pending right now, but of the 45 where we do have final orders, we have had 13 orders granted after a hearing in the Superior Court. We have had an additional 9 respondents consent to the entrance of an order, a final order of final Erpo. We have had 5 that have been denied after a hearing by the court and evaluation of all the evidence that was presented by both sides. And we have had 16 that have been withdrawn for one reason or another over that same time frame. And the reasons for withdrawal of the application kind of vary. One, we have situations where the firearms that have been seized are, as Jeff Burrill said, they're owned by a family member, and then that family member has sold the guns, or you see this a lot, I think, with juvenile or younger adult family members sharing a family home, and the parents make the decision that they'd rather have their kid at home than their guns at home. So they're either able to take those firearms. There are third-party storage facilities that can hold them and only release them to the FID card holding owner of the weapons, or they sell them. And so to those extent, while these hearings are pending, if we can be assured that the risk can be minimized or mitigated by removing the access that the respondent has to those weapons, we will withdraw our application. There are some other reasons for application as well. We've had a couple where we've withdrawn their applications because it turns out that the respondent is already subject to a final restraining order, has a domestic violence, and they are already a certain person, and their FID card had been previously surrendered, and they don't have legal ownership of guns anymore. Looking at those 45 cases, I can tell you that about half also come with criminal charges, and about half are just responses to either an ongoing domestic violence situation that has never been charged, or concerns with a respondent's mental health and ongoing treatment or crisis that they are in that has led either a family member to make that call or for law enforcement to make the call. And I think kind of to echo something else Jeff said, that of those 45 applications, they've all either been initiated by or joined by law enforcement. We're not going to make our civilians come into court with paperwork and try and do these on their own. And as a result, all 45 applications have been law enforcement originated or joined, as I said. In those 45, we have had only 1 that has been twice before the court, and we've only had 1 law enforcement officer who was a correctional officer at a state facility. I found that the way the court evaluates these applications, kind of the first, and the court does take a very lengthy examination of the evidence before rendering its decision, trying to balance, again, the real needs of a victim, the real needs to issue a final order of protection for a final extreme risk protective order, with the facts that a respondent may provide to counter those factors. And in some of our withdrawals and a couple of the denials, it has been where the respondent has been able to provide reports or documentation from a mental health professional to our satisfaction that the risk was transient, was not serious, or has been mitigated by treatment, inpatient treatment. And obviously, that's something that takes a lot more than 10 days. And we know we're supposed to go from to initial hearing in 10 days, and a lot of times, as Assistant Prosecutor Panfile will tell you, the first appearance, the respondents don't show up a lot of times. Maybe they're still hospitalized. Maybe the notice was a little bit, you're sending notice to the residents that they no longer live in because they also got a restraining order against them, and now they got to be at the hotel down on Route 130 or something. So we give them ample opportunity. We want to make sure that notice is genuinely sent, received, and the respondents have an opportunity to be heard, so that the process is secure and requires appellate proof. And a lot of times then, once the respondent does appear in court, again, even though these are civil proceedings, they are often the first question out of a respondent's mouth is, do I need a lawyer? The court is very generous with time in terms of granting respondent time to consult with, hire a lawyer, who then in turn will meet with or contact our office, and then will engage in that kind of negotiation, or that kind of like, okay, what if dad agrees to sell their guns? My guy's gonna be in a inpatient program for 28 days. If he has a favorable discharge summary, will that change your mind? So these hearings themselves don't necessarily resolve within that 10-day or even longer than that immediate 10-day period. But that's to our advantage as the state, because the Terpo still remains in effect while this is all playing out. So there's that. So while the process is working its way through the courts, obviously those individuals are still subject to the restraints of the temporary order, meaning that they would be a certain person if they possessed a weapon in the interim before final resolution. We did have one case where there was a double. I said there was one double applicant, and that was 2019. I think both of the applications were in 2019. And he was also a certain person due to a possession of weapons charge that occasioned the second Terpo. So we have had, I think, a fairly good relationship with the court, and an honest conversation with the court when we have these matters. We do evaluate them fairly. We do try to resolve them. As I said, we have, of those 45, more than half of them have resulted in the granting of a final extreme risk protective order by either hearing or by consent. And the ones that we've withdrawn, of those 16, again, it's because we as the state were satisfied that the risk had been mitigated, was no longer present, or were other factors that we have had where we have faith that there is no risk posed to withdrawing our Terpo and not proceeding to a Furpo in this matter, or in those matters. I'm happy also to say I do not know of any instance here in Middlesex County where one of those withdrawals has resulted in further harm or a further application for a Terpo against that same respondent. So to the extent that we've been able to take these honest evaluations, I think we've done so in a professional manner, and the fact that we haven't had return customers on those, I think, speaks loudly to the judgment of the court and the prosecutors who are assigned to these matters. As I said, we have had 45, we have 6 pending, and they've come in waves. When 2019 came around, there was a wave of filings. I think there were probably a lot of police departments that had individuals that would have, had this been in place 2-3 years earlier, they would have said, aha, this is the guy. And there was a rush of, there were a number of filings late in 2019, and then it kind of came, it came and went, and I think that the longer that our shutdown due to COVID lingered, I think, and I'm not saying anything dynamic here, but certainly mental health crisis has increased the longer people have been in shutdown, and I think we've seen an uptick as a result of some of the continued social anxiety and social distancing and difficulty in people seeking treatment that has come with a shutdown and relying on things like telemedicine and virtual mental health visits. But as I said, I think we've had great success here. Our relationship with the court in regards to handling these and scheduling these matters has been excellent and will continue to be so. And that is, in a nutshell, the local experience we've had here in Middlesex County. So at this time, I guess for anything Jeff or I said, we would welcome. And oh, by the way, we've had no, just to finish up because your screen is right here, we have had no terminations of Furpos come through Middlesex County since 2019.
So with that being said, any questions? Mr. Cradaville, what do you got for us?
Bradville, New Brunswick today. I want to thank you both for a really informative presentation. I guess my questions are based around whether this process has the same kind of confidentiality that surrounds domestic violence, and for example,
in my experience, it mirrors, the procedure, it pretty much mirrors the DB proceeding. The initial Turpo application is just closed to the parties. It's not available for public consumption.
Right,
Do you
yeah.
experience anything different?
Yeah, I mean, because well, first of all, the initial application for the Turpo is done, most often than not, done telephonically between law enforcement officer and a judge, so it's, and then the actual hearing itself, because the court is closed, because we do have that kind of sharing of, confidential mental health records and people saying, bearing their souls about the worst things that they do and the worst things that they've had to endure as either through as the petitioner or as the respondent sharing mental health histories. So there is that level of confidentiality there.
Louis Melton, Sergeant, Middlesex. Would that apply to officers also?
For the,
Privacy and all that, would
yeah,
that apply to officers?
it's the same standard for everyone involved in that procedure. It's closed court proceedings.
And the orders too would be sealed or would that be public knowledge?
In practice, I don't want to give bad information. In practice, I don't know if the orders are ultimately
Well-
sealed from public view.
I don't believe they are. And they need to obviously be shared with law enforcement so they can be entered in databases, so we know someone becomes a certain person, tries to, show a fake or expired FID card, or tries to get another FID card. Somehow, they've got a purchase permit that they can obtain, or they, but,
So I do know that that information
Yeah.
that you're referencing is shared in law enforcement databases where if a firearm dealer looks up whether someone can purchase, it shows as a hit that there's a prohibition, and that comes from law enforcement. I don't think they share that there was a Furpo or a Turpo. They just say the application is denied, same like they would if there's a restraining order. It's denied. I don't think you can reach out to the court and get a copy of a Furpo or a Turpo, but I don't want to give bad information, and I don't have experience with that.
I can't think of any, again, I have nothing better to add to that, sorry.
Thank you again for the presentation.
Any other questions? Well, before we conclude, I'd like to thank everyone for coming this evening. On behalf of Prosecutor Ciccone, Deputy Attorney General Jeff Burrill, Section Chief Judd Hamlin, I'd like to thank them both for this informative presentation. Just for the members of the public that are watching this via live stream, we will be back here again next Thursday evening for the Youth Bias Task Force. It'll be the second roundtable discussion of its kind. Previously had one, I believe, May of last year in response to the Youth Bias Task Force presentation and report that was issued in October of 2020. In addition, the prosecutor is also actively involved in a school security symposium at the Middlesex County Education Commission on February 23rd. For both of those events, more information will be on, or is on, the Middlesex County Prosecutor's Office website. So again, thank you very much for coming this evening. We hope you found it helpful, and if at any time you would like presentations on other law enforcement related topics, please feel free to contact us at the website, the email that's on the Middlesex County Prosecutor's Office website. So again, thank you very much, and we hope you found it helpful.